I think for the context of this discussion, something that, I should mention right out the gates, obviously, Michael being a CFA, me being a CFP, we are not estate planning attorneys, but I think something that's unique and maybe strategic to the conversations we have with clients as financial planners is we're on the front lines of these discussions and how these situations play out. So we've seen the byproduct of a really well executed financial plan, and we've seen what happens when things go wrong. And so what we're going to try to share today is just a culmination of decades of experience to help arrive at a short list of priorities that you should be thinking about when it comes to estate planning. So like Michael said, making sure the beneficiaries are done correctly. But I think it's very much about protecting your family, keeping things private too. So we're going to talk about, the avoidance of probate, a court interference. And so there's a plethora of reasons why this conversation is important. And something that I want to at least acknowledge in this discussion today is kudos to you for being here, number one, because it's an uncomfortable conversation. It can be a very morbid conversation, and it can also be a very boring conversation. It's very dry, and sometimes people like avoiding this. And I think what I've learned in just preparation for today's conversation is it's such a hard topic that it ends up unfortunately resulting in two-thirds of Americans not having any kind of plan in place at all. And that's the conversation we want to get out in front of and make sure that we're being proactive about having a plan. And so throughout today, Michael and I are going to talk about several different case studies that are pretty famous of things that we want of things not to do. And so we'll kind of jump right into it and talk about estate planning mistake number one, which is a very famous one, which is Prince. Michael, you want to take it away?
Yeah, this one is really difficult because it's arguably probably the worst situation you can have. Now, everyone knows who Prince is, great musician, singer, songwriter, everything. But one thing he was not good at was putting together an estate plan. He actually died in what's called intestate, meaning he died without a living will or died without having a will in general at all. When he left a nine-figure estate. Now, the unfortunate piece of this is it's not just a simple one person inheritance that would go to somebody. There were potentially six individuals that were claiming inheritance, and then the court had to go through an entire process of valuing, looking at creditors, opening it up for the public's opinion before identifying who are the actual potential beneficiaries. This was complicated because there was actually potentially an additional beneficiary from inside of a federal penitentiary who claimed to be a relative that should have received assets. This process took years to actually come to fruition and close out. And I think, John, you talked a little bit about, 67% of America doesn't, have an estate plan. The unfortunate piece is, a third of America has an estate plan the way they want it. Those that don't at least write a will
Hmm.
leave it up to the courts. And the problem with that is we don't really, the court doesn't know what you want to have happen like you probably do. And much probably like in this case, Prince probably had feelings about what he wanted to happen to his music, his assets, everything. Ultimately, it was left up to a judge to divide out and move along. And that's the really dangerous piece about this is, you know, it's a difficult conversation to have. What do I want to have happen to my assets, my kids, my family when I pass? But if you don't make that decision or have that conversation, a court's going to for you. And I think that is potentially the more complicated piece here.
Yeah, so let's talk about that because something that I've kind of coined internally in conversations I have with clients is like the core four. So typically, when you hear someone say, "I have a will" or "I have an estate plan," a lot of times like they're kind of focused on this piece right here, the last will and testament, but there's a lot more to it that needs to be in place. Michael, where should we begin here? You want to start with the living will?
Yeah, let's start a
Okay.
little bit with the living will here because I think this is the one that people think of right away, or they they should be thinking of right away. This is the
Mhm.
directions for what happens to you when you can't make decisions for yourself, but specifically centered around end of life type
Yeah.
decisions, right?
Yeah.
Because we also have the healthcare surrogate, and that's part of this potentially. But this is really an act of love that you give to your family members, right?
Well said.
Because you don't, you know, everyone says, "Oh, I want my daughter, my son, my husband, brother, whoever it is, to make my healthcare decisions for me. And that's true. But you don't really think about, well, like what happens when they need to make the decision of doing life prolonging care or not. That's a
Hmm.
very heavy thing to put on somebody. This document takes care of that. This lines up your wishes at that part of life.
Yeah, it's what's known as an advanced directive. So you're basically, it's kind of like a medical script for your doctors and your loved ones to understand what you outline and what you want if you're in a coma or in a more terminal situation. And I would agree with you, Michael. I think this one document can really help reduce stress for your family more than anything else because it takes that decision away. Like they're not having to infer or try to figure out maybe what you wanted or didn't want. You've
Yeah.
got that really, spelled out. And moving on from that document again, as I mentioned when I was sharing a moment ago on that previous slide, the four that we had, the last will and testament, this is kind of your chance to say like this is who gets what after you pass. Right. So without a document like this, state law is going to determine, and obviously that might not align with your intentions. And also, if you have children that are under the age of 18, this is the document where you can name a legal guardian. So without that, the court's going to make that call. And I think for parents, this one's a non-negotiable. This is something that my wife and I, when we were starting our family and had Hudson and Ella, this was a big deal for us to have these conversations and make sure that this component of it was set up because it's very essential, especially if you have minor kids, like I said. Any thoughts on
Mhm.
this one, Michael?
Yeah, I think this one's key that this is not avoiding probate whatsoever. It still goes through probate, but it's really kind of
Hmm.
like the map to the assets. This is really where you're saying, here's what I'd like to have happen. And then
Yeah.
you go through the process to make those things occur.
It's a good tee up for a few slides when we talk about probate avoidance. So, moving on with the core four, and again, this is what I think any family should have established. The next one's the durable power of attorney. So this gives someone else, typically in a situation where if you're married, it's going to be your spouse first, and then maybe a trusted family member second. If you're not married, it might be a trusted family member. But this gives them the legal ability to manage your finances if you're unable to. And Michael, I know you have strong feelings about this one because there's a couple things that are really important. For example, one of the line items on here is that can be broad or it can be limited in scope. Do you mind just elaborating on what that means? Because I know you've seen this work in real time with clients before.
Sure. Yeah. So this is an incredibly powerful document because it allows people to make business decisions on your behalf. Now, things to keep in mind, it's in effect as soon as it's signed.
Hmm.
So you want to name an individual who you trust. Now, you don't have to give them that document, but you should probably let them know where it's at in case it's needed. But the other thing here is it can be broad or limited, meaning it can say, this is my power of attorney. They can do business on my behalf. That's very, very, very broad.
Hmm.
However, it may be very limited in scope and say this person is able to sell my home for the use of funds for my nursing facility that I'm going to go into. Or this person is going to be able to pay my bills and delineate certain things, and it's specifically going to be targeted there. Those are a couple things to keep in mind because without this, no one can do anything business-wise for you. You really need a court order to begin to make those changes or decisions if you don't have this power of attorney on file.
Yeah, and then I think, a good parlay to that is the healthcare surrogate or the healthcare power of attorney. So it's very similar in nature, but this is going to be for healthcare decisions, medical decisions, instead of maybe financial ones, as Michael was referring to. And also, I think something that's very important to know here is to make sure that when we're thinking about our healthcare power of attorney, that we also get the HIPAA release as a part of that. Because
Mhm.
without that, your agent, the person that's like representing you in that situation, might not be able to get access to things like updates from a hospital. We've seen families go through stuff like this. And I think that this is where, having these documents in place ahead of time, spelled out the way that you want them to, you can really help alleviate a lot of heartache and avoid just a lot of frustration by having some of these simple things in place. Now, you're probably waiting for the next conversation like this like really cool gentleman is that's super relaxed, which is, well, what about a trust? Because we talk to folks a lot about that too. It's like, do we need one? Do we not need one? And I think it's circumstantial. I would say, Michael, I'm curious of your opinion. I mean, like for me, the core four that we talked about, just backing up a moment ago, those feel almost like non-negotiable to me. Like I just feel like you need that because even if you go, oh, well, maybe financially I'm not in a situation where I have enough assets to worry about it and I don't own a home and so on and so forth, but I've got children, like, okay, it still calls for that scenario where you need to have those documents in place. A trust is a little bit different, but what are your thoughts there?
To me, a trust is about control
Hmm.
after you pass. And it's how and why you're going to exert that control. So a couple things come to mind right away. Like if you have, significant assets with minor children, you probably want to trust to, even probate takes a time to go through. So maybe a trust to administer to their needs while they're going through probate or so they don't have to go through that probate process.
Can we touch on that part real quick, Michael?
Yeah, go for it.
Just to clarify, I mean, I think that's one of the biggest advantages of a trust, but it allows your assets, if your assets are placed in the trust, to completely bypass the court process. And I think that part in theory doesn't seem like a big deal, but if anyone that's listening to this, and I see some names who've experienced this, like if you've ever experienced the probate process and how long it can take, and then just the frustration of like, okay, well now, how am I gonna have access to assets and so on and so forth. It's a big deal. If we can avoid delaying it, I think it's pretty important.
Yeah, because one of the things about probate that's really unfortunate is it's not even the process is expensive, it's clunky, it's time consuming, it's not private.
Hmm.
You're opening up assets and valuations to the public, and that can be problematic. Now, talking about the control of more complex situations, what if you have a family member who has struggles with gambling or other addictions? A trust can protect them. A trust can protect blended families. If you have a significant amount of assets and you want to care for your wife, but you don't want other situations to take advantage of her down the road, a trust can do that. There's a
Hmm.
lot of different things that you would do, but I think you kind of said it in the very beginning about the trust. The trust is very circumstantial towards the individual or the couple,
Hmm.
and really goes down the line of why are we creating this and what are we trying to control? What are we trying to avoid in this situation?
I like how you explained it before on the core four that I'm saying is non-negotiable is that, the living will and testament is just kind of like a roadmap for things. That doesn't mean it's going to avoid probate.
Mhm.
Whereas the trust is the thing that actually helps you do that. Now, for context, I do want to clarify, we're not referring to an irrevocable trust. There's different types of trust that can be created, but by and large, I mean, it is circumstantial, but when we see a trust created, it's typically this one, which is known as a revocable living trust. Now, I agree with you. I think, it can be for more complicated situations. So if we want maybe more control over assets, like we want the home ownership inside of something like a trust instead of outside of it, or we have a blended family, or something else that I kind of want to call the attention to because we've seen this too. It's like you have adult kids, great, and so in theory they're at the age they're in their late 20s, and if you were to pass away tomorrow, they should be responsible enough to handle those assets. But there's also things like spendthrift conditions that you can place in that trust too, Michael, where
Mhm.
you can have a scenario where you can, if maybe gambling or addiction is an issue for that adult child, you can put restraints around that for a trustee to monitor the conditions for that person before they were to receive assets. Now, I know that's kind of tricky, but I just wanted to give another example.
Yeah. But I think you actually hit on something that's really important is actually what's called funding the trust.
Hmm.
And that's something that is a estate planning pitfall, but simply going to an attorney, getting a trust written up and then signed doesn't necessarily do you that much good. You have to take the assets that you want and then title them in the name of the trust or name them as beneficiaries to the trust, such that the trust has assets. That's something
Michael,
that's
that's a
very key.
question. Yeah, thank you for saying that because we got a question about it. So basically, the question is like, what does it actually mean to fund a trust? Because I think sometimes people confuse that part. Like, I always use a football analogy. I love that. It's like we get the ball to the 1 yard line by creating this trust, and we spend all this time and energy and money to create it, and then like we don't punch it in the end zone because we don't fund it. And it almost like I've been there before with like attorneys, and we're sitting in this meeting like, well, you need to fund the trust, and it almost sounds overwhelming because it sounds like it's overly complicated, but it's not really. Like the trust is in the name of it's in your name, it follows your social security number. It doesn't create any kind of like additional tax confusion. But given maybe an example of what funding the trust looks like.
Let's say you have a home, you own your home, and you want to put your home in the trust. In this case, you do a quick claim deed and you take it to the tax collector or property appraiser office. Every county is a little bit different on who handles it specifically, but you go there, you show them the documents, and then quickly the home gets retitled to the trust. Another
Mm,
thing would be the Michael Scott individual brokerage account. If I open a trust, I show JW Cole in this case that I have an individual account and I have a trust now, and I ask them to retitle it, and we do some paperwork, and now the account that I had, my brokerage account, is in the name of the trust. Same thing with checking or savings accounts. Anything you really want to put into it
mhm.
can be done that way.
Yeah. Yeah. And so you might be listening to this conversation today and maybe thinking to yourself, okay, so great guys, I've already done this. I set up my core four, I've got a trust in place, I'm all set, right? And that kind of leads us to case study number two, which Michael, you alluded to a little bit at the beginning when you were talking about beneficiaries.
Yes, so the core four, the trust are all important, but as unfortunately Barry White found out in 2003, or I guess didn't find out because he passed, beneficiaries are incredibly powerful and they live outside of these documents. In Barry's case, when he passed in 2003, he was separated but not yet fully divorced from his first wife. He did not update the beneficiaries on different accounts, even though he had a new partner and I believe a child as well with this partner. All of his assets went to his ex-wife or his soon-to-be ex-wife. Nothing went to his new partner or kids. And that's something to really consider. And it's interesting because the reverse of this was Heath Ledger, where he didn't put beneficiaries on anything, so his daughter didn't get anything right away. It's really important to know that if you have an IRA and you name a beneficiary, we need to keep track of that. We need to take a look at that at least every year to make sure that's the right person. When we think about that, like what if you, a lot of times people can forget if they got divorced or they got married recently, any life changes like that, that beneficiary should be updated or should be. I've seen this happen before where an insurance policy that someone forgot they had, they never updated and they found out that it was actually pointing to an ex-wife. And
Yeah.
I can't imagine passing and then leaving someone something that you didn't intend to and not leaving things to the people that you wanted to leave them to.
Yeah, and I would say it really is one of the biggest surprises that people find out about. Hopefully, before it's too late, of course, but to understand that, man, I did all this stuff. I did all this legal process and I created this trust, to make sure that money goes to the family members I needed to, and it's charitable the way I wanted to, and everything's spelled out exactly the way I wanted to. And then to find out that the beneficiary designation you might have listed on your IRA or a 401k or something, or a life insurance policy, that's going to completely override and be given priority to that trust is really eye-opening, I think, for
Hmm.
people to say the least. And so, something that we advocate for as you're reading this slide is to do an annual audit, for the clients that we serve, that's something that we're looking at on a pretty continual basis. And we'll bring it up from time to time in meetings, just to make sure, hey, are the beneficiaries aligned with your wishes now and in conjunction with what you have set up in your estate plan? All too often, that scenario where You think about Michael, like someone starts at their company, they set up a 401k, and I have seen this, but they put no beneficiaries because there's no money in it yet, right? So,
Yeah.
they're like early in their career, and like, it doesn't matter. They leave that section blank. Fast forward 20, 25, 30 years, there's a significant sum of money in there, and it's still blank because they never thought to revisit that. And so, an annual audit, I think, is something very important. And what I do want to mention when we do, we've been trying to do these webinar series on a monthly basis for our clients, and a lot of it is, I think our ambition is to maybe spark motivation for a conversation in between meetings. So if there's ever something where it makes you think and say like, hey, I need to meet with Michael or Matt or John and talk about this stuff. That's kind of our ambition as we're doing these. So maybe the next meeting we do is an annual beneficiary audit, but again, I think that stuff's really important. And we had a question, Michael, that I want to throw out to you. So, because it kind of like ties into beneficiaries on the trust. Okay.
Yep.
So I've listed my kids as 50-50 beneficiaries and everything, adult children. Is that okay, or should I name the trust instead? How would you answer that question? Putting you on the spot.
Well, you named a couple things just in your question, and there's a couple considerations there. So as you name it, as you ask the question, I have a couple children. I name them 50-50 beneficiaries. They're adult children, and you have a trust. There's nothing wrong with naming your adult children beneficiaries if you feel like they're ready to have it. I would ask the question or ask the clarifying question, is there anything in the trust that would regulate when they should receive the assets?
Mhm.
Because the beneficiary designation is going to give them the asset day one. If that trust is delaying any payouts till 35, 50 years old, whatever the number is, we might want to point it to the trust. But then let's back up and say, well, John, your two kids are under the age of 18. In theory,
Be a real problem. Yeah.
you could leave them as beneficiaries on it. Do you want to leave your children your assets? Yes, but do you want to leave your kids under the age of 10 the assets at that point?
Of course
Probably
not.
not. So those are the things when like we would point them to the trust. It really depends on your circumstance. Some people say, "Hey, my kids are, they're over the age of 18. They're adults. I'm past. If they haven't learned how to manage their money at that point, that's on them." Other people are very sensitive about it and want to make sure that there are steps taken. Both options are okay from a planning perspective, but it really points back to what do you want and how do you view your family and your wealth and what are your goals with this over time?
Yeah, yeah. Well said. And also, some people are charitable with their intent, and they want to make sure that that's a component that's a part of their trust as well. So, again, as you've said a couple of different times, I think it's very much about control. So, we've talked about that. We've talked about making sure your beneficiaries are aligned, doing an annual audit of that, having the core four documents, and why that's important with some case studies, and then considering a trust. What are some final checkpoints that we think, just as we're rounding out this conversation, we're closing in on 30 minutes. So any final checkpoints for you, Michael, that you want to touch on?
Yeah, there's a couple here on this page. One I want to point out is the DIY documents can cause chaos. And the
Hmm.
reason why I say this is because if you can go online and you can get a trust and it will be a trust and it will be legal. But something we talked about now is that what if you leave your spouse the primary beneficiary of your IRA, but the contingent is the trust? And your intent is for that trust to distribute the assets to your children over a normal time period. Well, if you don't get the trust with the right language in that, you're actually setting up an absolute chaos situation for an individual to inherit an IRA into a trust. And there's a lot of technical tax issues there. But there are specific things in trusts or other documents with the right language. Having a power of attorney that is very broad in scope, but you meant it to be very limited in scope. Things like that are important to take a look at. And then The last thing that I have here is keeping the plan a secret. This is something that I've come across different times in my professional career that's sometimes puzzling as a practitioner, is that families don't share the documents, what they say, where they're located with their loved ones who they're written for,
Mhm.
and that can be very problematic as well.
Yeah, I think that leads us to estate planning mistake number three. And but I do want you to touch on that before we do a couple things, or maybe just one thing that I want to mention on here.
Hmm.
And this may seem just so obvious, but just like we should check our beneficiaries on an annual basis, we really should look at the estate planning documents that you've created anytime there's a major life event or transition in life. Transition could be career, you're moving from working to retirement, or you have kids or grandkids. Like anytime something material is going to be changing in your life, it could be
Anytime you're moving,
yeah,
you change
yeah.
states. Think about that.
Oh, thank you for saying that. Yes, you change states. We had that example, that exact scenario. Clients of ours moved from Florida to Oregon, and the topic of conversation came up like, hey, we probably need to do an audit and update these documents. And they were like, well, we did it all already. It's everything set up. Like our wishes haven't changed, right? And you know what I'm about to say, Michael, which is this is guided by state law. So state
Yep.
legislation determines this. So you have a trust created in Florida, you move to Oregon, we need to have the trust updated, amended so that it reflects Oregon state laws. That's a really huge deal. So thank you for saying that as well,
Mhm.
Michael. Now, going to, I think, where we were kind of headed in the next slides is something that is, a good case study and very important to you, as you said a moment ago, Michael, but keeping it a secret. Can you talk a little bit about that?
Yeah, so this is Flojo, an Olympian from, I believe, 1996 Olympics. Sprinter.
Hmm.
Unfortunately passed, I believe, at the age of 38. Had a husband and also had her mother living with them in a condominium that they owned. And unfortunately, she passed, and there was an estate plan, but nobody knew where it was at. No one could produce it. And the mom claimed that she was told that this document said that she could live in the condominium for the rest of her life rent free. Husband disagreed, and I don't know the specifics on why, but neither party could show this estate plan.
Hmm.
And, from an outsider's perspective, not knowing the specifics, if this condominium was owned by Flojo and her husband, you know, John, correct me if I'm wrong, but he probably has a better claim on that than her mom does.
Yeah. Yeah.
And regardless of, the situation, like that's a problem because if this document existed, this isn't a discussion. But now we're pitting family members against family members after an untimely death. So, this is just an extreme example of what can happen. But if you're going to go through the process of putting all these documents together, make sure somebody knows where they're at, whether that's the attorney, whether that's your financial advisor, or your close family members. Oftentimes for us, we keep electronic copies for a lot of our clients, but
Hmm.
make sure somebody knows where it is. I know my mom tells me all the time, ours are in the closet in the fireproof box in case the house burns down. We'll go find it. But it's important to make sure somebody knows where these documents are at.
Yeah, it's so funny you say that, not funny, but I mean I've had clients tell me that too, where they're like, okay, it's located. If you ever need to know, it's located in this
Exactly.
discrete location in my house. I'm like, I've never even been to your house before. I'm like, does someone else know where this exists? And so I'll agree with you, Michael. Something that I think is very important is making sure your financial advocate has a copy of those documents digitally saved, and this. And I would say most of our clients that are on this have had this experience with us too. The MyPath client dashboard, that vault section that's in there, having those documents securely saved there as well so that you have digital access to it at your fingertips. We have access to it as well. And then, your loved ones that you would want to have access to it, maybe that's a successor trustee if you want them to know where that is. I think that's really important. And then of course the attorney that might draft it should have that as well. Michael, we got a question. Drafted my will in 2016. How do I know if my documents are out of date? And I would say my gut response is if, even though in a blink of an eye, I mean, it's like, it's not even, we're talking 10 years or less, but a lot can happen in that time. And so I think it's worth a conversation with the person who drafted it or having some type of, financial advocate look at that to see if it's still, because I mean, number A, laws change, over time. So that there could be that. And then there's also big life transitions. So it's hard to say if it is outdated, but a 10-year-old document, I think, deserves an audit. What would you say?
Yeah, I would say you probably need to audit the actual documents every 3 to 5 years. And like
Hmm.
you asked that question, documents, depending on your situation, could be outdated as of 2017. Why 2017? The Trump tax cuts changed the estate exemption. They, if we don't get tax reform or a tax bill, estate documents could be outdated at the end of this year. The Secure Act 2.0 in 2021 changed how IRAs were handled. So there are a lot of laws, like you say, that change or Congress does that can definitely change these estate documents. So, every 3 to 5 years, you probably should take a look at this, whether it's with your financial advisor or the attorney, and make sure that that happens. But also think, anytime any big life event happens, are you moving, job changing, marital status changes, or relationship status changes, kids, grandkids, anything like that you'd want to be noted on, that's probably a good opportunity to review.
Yeah, and I think obviously these next steps up here on this slide sort of speak for themselves. But again, I mentioned this on the beneficiary page when we were talking a few minutes ago. The hope for us, is if this sparks a conversation to make sure that we're having that with you and we're being proactive in between normal review meeting cycles. So if you want to chat with us, we have a network of attorneys that we use. So obviously, as I mentioned this at the beginning, like we're not attorneys that draft the documents, but we do work with attorneys who do this aspect to it. And then we make sure, as your financial advocate, that aligns with what your financial goals are in your current financial situation. Michael, final question here, and then we'll go to the last slide. Titling the home in the trust. Thoughts on that? I mean, I think it's conventional wisdom that for most families, if you set up the revocable living trust, that you do go through the steps of titling the home in the trust. Now, there's, I believe, circumstances in which some families don't do that. Any thoughts there without going into the realm of like you're giving legal advice?
Yeah, I mean, I would start off by saying talk to an attorney.
Great,
That,
great
that
start, great start to the
that'd be
answer.
number one. I don't generally, I think it's so generally, I see a lot of people titling their home in the trust. Now,
Mhm.
there are reasons why you might not want to. Potentially, you should, have the home owned jointly and point to the trust elsewhere. There's also, there's something called a ladybird deed, where you can do something with that without going too far into another branch of estate planning. You have options.
And the effort of that is to help you avoid probate on the transfer of that asset. So you have an
Yes.
illiquid asset that you can't name a direct beneficiary to, like a home, and you want to avoid the probate process and directly, get that to somebody. A ladybird deed can execute that. A trust can also execute that.
Yeah.
And this is the follow-up part to the question that I didn't ask yet, but I'm just going to ask it, and I know
Go
what you're
for
going to
it.
say, but it's, does that disable your homestead exemption? Oh, it gave me a thumbs up.
Oh, no, it does not. You still get your homestead exemption. A key thing about the trust, like you said earlier, we're talking about a revocable living trust.
Mhm.
While you are alive, if it's an individual trust or a trust with your spouse, however it's set up, while you are living, it's living within your social security number. At the point of which you pass or both spouses pass, then it becomes irrevocable and that's a different situation a little bit. But as that home is in the trust and you're still alive, you still get your homestead exemption. So you don't lose anything there.
Yeah, great answer. Michael, as we're wrapping up, I'm curious if you just have any parting words of wisdom just to tie a nice ribbon on it. I think one thing I want to mention, the ambition for this is to just spark the conversation, make sure that there's no gaping holes or minor problems that need to be adjusted or corrected when it comes to your estate plan. The beginning slide, it's easy to avoid this. 2/3 of American families do, but we don't want our clients to be in that situation. When we do these webinar series, we do these each month, and we host them later for our clients that weren't able to attend to join it and watch it. So I'd love, as everyone knows, I love our marketing efforts, and it's for us, it's just an extension of the work we do in client meetings and trying to stay connected with our client community. And so for those who haven't yet, would love for you to take a picture of this QR code, and it'll take you directly to our YouTube channel to subscribe there, which this video will be hosted there. So if you'd like to reshare this to somebody, you certainly can do that. But Michael, any parting words of wisdom as we're wrapping up today?
I think the easiest thing and the things that, I'm going through right now is just take a step back and look at where your assets are and just look at the beneficiaries, because those are the easiest and quickest, cheapest things to fix, but they're also probably going to have some of the largest impacts right away.
Mhm.
So that's where I would say most people to start. Think about, did I have any life changes? Do I have any new family members? Did my relationship status change? Then go look at the beneficiaries, or ask us if you're working with us, ask us to take a look at it, and we'll tell you what the status is. I think that's probably the best starting point for most people paying attention.
Yeah, well said. Let's do the beneficiary audit, make sure life insurance is even like things that people don't conventionally think about. You've got like, oh, I got a one-time salary death benefit life insurance policy at my company plan. Who did I name again? Like how is that like those types of things?
Yeah.
Just leave no stone left unturned, and take a look at those things. And as always, ask us questions. That's why we're here, to be your financial advocate, financial planner. And if and when you say, hey, we want to talk with an attorney, if you have your own, great. But if you need an attorney reference to someone to connect to, we've got a great network of attorneys that can do that type of work. But today's goal is just to get good information out there. So I'm sure, we're now 42 minutes in, Michael. So I'm sure everyone's like super amped about this estate planning conversation, but it's a good one. It's an important one. And we'll be curious to hear where everything lands for you once you guys are done with the wedding and get to do your estate planning.
I'm sure it'll be a fun process to walk through everything, but we're looking forward to it.
Yeah, for sure. Congrats on the wedding, buddy. We're
Thanks,
excited
man.
for you. Thanks to everyone for joining us today on this webinar. We do these every month, so we'll send an invite out to the next one for next month. Until then, reach out to us, send us an email, text, call, however you want to reach out to us, and we'll chat with you and get everything sorted out. Okay? See you guys.